All right, so fair housing. You guys are lucky I could not see you today. I'm trying to pick on who's not on camera, but I can barely see you guys. All right, so fair housing. Please let me know what do you think about this fair housing. When you see fair housing, what are we talking about? Without reading, give me your opinion. If it says fair housing, lending laws, okay. Equal opportunity, no discrimination, exactly. So this chapter is about equal opportunity in housing. Okay, this chapter is about equal opportunity in housing. All right, so federal, state, and municipal laws governing human rights and non-discrimination must be known by licensees who provide housing or land for sale or rent. Under the terms such as open housing, fair housing, and equal opportunity housing, these statutes prohibit undesired and discriminatory conduct. Their regulations impact the entirety of the real estate sales process from listing to closing, and all brokers and salespeople must abide by them. Okay. Individuals and families can attain and sustain a satisfying lifestyle if they can purchase and rent an adequate home. Housing discrimination is harmful to its immediate victims and reflects poorly on the society that permits it or allows it, right? There's state fair housing legislation. So there's federal laws and obviously state laws. Even though the states have established fair housing laws that typically match the standards of federal law, each state may have enacted slightly different measures. Real estate students are obligated to learn and understand their state laws, and in particular, the areas in which these rules deviate from the national fair housing regulations. So what I'm saying here is very simple. The state law, the way it works is you have constitutional rights and laws, right? The supreme law of the land. We have the federal laws, and then the state laws, and then county laws, municipal laws, and so on. So it trickles down, right? One cannot go against the other. They can be an extension, and they can be stricter than federal laws. They just cannot go against federal law. Okay, so each state has their own rules when it comes to fair housing. Fair housing and local zoning. The Fair Housing Acts forbid the wide range of discriminatory housing practices based on race, color, religion, sex, national origin, marital status, and handicap. The act does not supersede municipal zoning regulations. However, it applies to municipalities and other local government bodies and forbids them from making zoning or land use decisions or implementing land use policies that exclude or discriminate against protected persons, including those with disabilities. So like I said, the local municipality cannot be discriminatory. We will talk about that in a later chapter as well, where state of New Jersey is known for it, and the law in New Jersey was spread through other states as well, which was exclusionary zoning. So when we're talking about zoning, exclusionary zoning is where some towns say, hey, we're going to develop to be a luxury town, and anybody that's middle and low class or middle and low income needs to be kicked out of here. That is illegal. And that's based on New Jersey law, became federal law, and now almost all the states have some type of variation of this law. Okay. So in short, when the legal action is necessary to address wrongdoing, everyone benefits. Understanding and working within the context of fair housing rules is essential for establishing and sustaining a successful and ultimately lucrative real estate market for everybody. Failure to comply with fair housing practices is not only grounds for license revocation, but also a criminal act. So This is right at the beginning, not at the end of the chapter. Right at the beginning, giving you a warning. If you don't understand these rules, if you don't follow these rules, the fair housing rules, if you intend to discriminate, all right. I don't know who, what I think it was Lewis got up. Oh, he's going to talk about discrimination. Let me get out of here. I intend to discriminate. Let me now listen to the criminal part. You could get out, Lewis. All right. I was just messing with you. But yeah, if you guys don't follow this, if you intend to discriminate, then it's going to be a tough road for you. Now, unfortunately, I also mentioned here in the book that unfortunately, even though these rules exist, they're very recent. Believe it or not, they're very recent. Even though the very first one's from 1866, to the point where it took 1,866 years, just Anno Domini. We're not talking about before Christ. We're talking from year zero, right? It took 1,866 years for us to set up a Civil Rights Act and say, hey, let's not discriminate, right? So when I say they're very recent, they're very recent. The next one is from 1968. So it took another 102 years before they said, maybe we should include more groups, protected groups or classes into this. So these laws are very, very recent. They're not enforced. And I think you guys know this. They're not enforced. When it comes to discrimination, this is not, Civil Rights Act is not just for housing, okay? It's in general, it's a civil rights. Title 8, which we'll talk about next, Title 8, the Fair Housing Act of 1968 is specifically for housing. It's an amendment to the Civil Rights Act. But it's not, people are discriminated every day, right? There's racism every day. There's, it's tough because at one point it looks like we're getting better, and then all of a sudden, a political race screws up everything. Specifically, I'm not bringing politics as far as one president or another. That's not what I'm saying. But it's funny how political races over the past, especially over the past 10 years, 12 years, like dramatically set us back. Like we were doing way better. And then all of a sudden, come back. All right. And discrimination is on the rise again. It's crazy. So what you're going to learn today is that these laws exist. What you're going to learn today is that the penalties are heavy for this type of discrimination, including unlimited punitive damages. Punitive means punishment, right? That means the judge can say, you know what? Just as a punishment, you got to pay $10 million. Whatever the judge feels like that day, right? Because that's how law works, right? Have you ever been to court for a traffic ticket? Have you ever been to the court for a traffic ticket where the person in front of you had the same type of ticket you did, and they got away with it and you had to pay, right? It happens. It depends on how the judge feels about you, how the judge feels that day, and it depends on the attorney that's talking to them. They're best buddies while on the golf course. So, hey, Your Honor, I'll buy you a drink. Can you dismiss the ticket? Right? So the law, even though we have black and white, right, is very gray when it comes to the decision maker, the judge, right? Anyway, but you're going to learn about all this in this chapter. So the very first one, this is almost anything is very difficult to prove in court, Stephen, almost everything. But yes, this is one of those things that's very difficult. But the discrimination laws clearly state that the ball is on your court. So the way it works is the person that felt discriminated against only has to complain, does not have to prove anything. When it comes to discrimination, you can go straight to federal court. We're going to go over this. And all you have to do is say, hey, discrimination happened. The defendant is the one that's going to have to prove that discrimination did not happen when you're licensed. When you're licensed. If this is, let's say, me and you on the streets, and we're not talking about a real estate transaction, that's a different story. When it comes to housing, because you're the licensed one, okay, it weighs heavier on you always. It's like being a doctor and they give you the wrong pill. Well, but he told me he had a headache, so I gave him a pill for the headache. Well, did he tell you had a kidney problem too? You know what I'm saying? So it weighs different because you are the professional that should be asking questions, that should be looking out for this stuff. That's why you gotta pay attention to this chapter. In fact, it is part of professional practices, which is heavily tested on the exam as well. Okay, so let's start this. You see this date? This date says 1866. Now, you can remember the Civil Rights Act, or you can remember just 1866. Me personally, I think 1866 is the easiest thing to remember because there's no other 1866 in the book. No other reference to 1866 in real estate law, okay? So it makes it easier to remember that the original Fair Housing Law, Civil Rights Act of 1866, prohibits discrimination based on race. That's what you have to remember. 1866 prohibits discrimination based on race. 1866 prohibits discrimination based on race. I'm going to mention several times that under the 1866 law, a Greek person can seek remedy if it was based on race. There are exemptions, but there's no exemption for race. So the restriction applies without exception to selling, renting, inheriting, and conveying real estate, regardless of whether the transaction is handled by a real estate agent or the owner sells or rents the property by him or herself, right? When race is involved, there are no exceptions. So 1866 law has no exceptions. So when you read the question, there's going to be a few trick questions that we'll talk about. They will talk about classes or protected classes or races or whatever. If the question is related to race, or if it asks you which one of these classes has no exemptions, race, always race. Okay. Now, while the Civil Rights Act of 1866 prohibited discrimination, it was only marginally enforced. As I was saying, it was not heavily enforced, right? In 1968, a federal statute was created that prohibited discriminatory practices in the real estate industry specifically. So it was very broad, very difficult to enforce. But this act came to be, Federal Fair Housing Act of 1968. This is another date to remember. Another date to remember, 1968. So in 1968, they added, even though there's references to color in the 1866, it was enforced specifically for fair housing under the 1968 law. So 1968 law is strictly for housing, and it talks about not discriminating when it comes to race, color, religion, or national origin. Race, color, religion, or national origin. So where you came from. Okay, these are the things to remember. I'm still going to read the rest of it, but I'm trying to show you quick association. Okay, I've been doing this part for years, and it's what's been most effective. 1866, race. 1968, race, color, religion, national origin. If you guys do it like that, when you go look at the questions and the answers, it'll be a lot easier to figure out which one is which. Okay. So Title 8 of the Civil Rights Act of 1968 is known today as the Fair Housing Act, prohibits discrimination in housing based on race, color, religion, or national origin, and was later amended by the Housing and Community Development Act of 1974 and the Fair Housing Amendments of 1988. Notice that I'm not highlighting the years. I'm not underlining the years. It don't matter. Okay? There's no question in the exam that says, hey, what happened in 1988? What happened in 1974? There's a reference to, might be a reference to 1866 and might be a reference to 1968, which are the most important ones here. But in 1974, they added gender and familial status. In 1988, they added disability as well. So when you see this word familial status, it has to do with households with children. Okay, so if there's somebody under 18 in the household, they're considered familial status. It's protected. People with disability, we're going to go over these definitions in a second. Sex, we're talking about gender, of course. And the Office of Fair Housing and Equal Opportunity administers and enforces Title VIII under supervision of the Department of Housing and Urban Development. Okay. The next one is HOPA. This is another one, by the way, that it's in this in the state exam. It's the funniest thing. Like I've been going through, I went through 4 versions of not 4 versions of the Dearborn edition for the real estate book, and another book that I was using before, and another book that I used before. And HOPA, even though it's asked in the state exam, HOPA is not in any one of them. They do mention what I'm about to mention, what it is for, but they don't mention HOPA as Housing for Older Persons Act, right? They don't mention this specifically like this. They just mention that there are protected classes for senior citizens, certain types of senior citizens, which we're going to go over. One of the questions in the exam talks about HOPA. And I have people come after the exam, come ask me, Bruno, what the heck is HOPA? I had a question about HOPA. I'm like, Housing for Older Persons Act. I mentioned verbally, it's not in the book. And I guess whoever it was at the time was not paying attention to what I was saying. So I did not write it down. So I started making sure that every time I was teaching, I say, hey, right here, this is HOPA. Please write it down, okay? Because sometimes that's what they do. Like there's another question in the exam, which we're going to talk about when we get to the Jersey portion, which has to do with the water treatment, okay? So it's the Water Treatment Act when we have wells, for instance, and instead of putting the whole thing, Housing for Older People's Act or the Water Treatment Act, whatever, they just put the acronym. Like in this case, HOPA. In that case, it's PTWA. And we're like, what is that? So if you don't associate things, it'll be very, very difficult. I don't know why. We instructors have challenged PSI already, by the way. We've challenged PSI because they don't give us access to their exam, right? I know the questions because I take the exam once in a while, and because I asked you guys for over 7 years, I've been asking you guys, whatever you remember, let me know. You know what I'm saying? And that's how I've been building all this, leading to this. But PSI, it's like, it was 400 of us asking them, hey, give us access. Let us know what you're putting there so we know what we teach. And they're like, nope. And the state doesn't do anything. Samaya, you said familial status is for children under 18. So households with children. Children are considered people under 18, yes. We're going to go over this again. All right, so HOPA. You have to remember HOPA, very important. It was passed by Congress in 1995 and repealed by the requirements that housing for people 55 and older includes significant facilities and services intended for seniors. So it has to be intended for seniors. HOPA specifically exempts 3 types of housing for older persons from liability for familial status discrimination. So they're exempted from familial status discrimination. What does that mean? If it's intended, very important, Intended for seniors, can I say no children allowed? Yes. If it's not intended for seniors, can I say no children allowed? No. Okay. So exempt housing facilities or communities can lawfully refuse to sell or rent dwellings to families with minor children only if they qualify for the exemption. To qualify for the housing for older persons exemption, a facility or community must comply with all the requirements of the exemption. This is taken directly from HUD, word for word right now, directly from Housing and Urban Development. Some of the stuff that I put here, I went straight to the law and put it here because it's very specific. So housing for older persons exemptions apply to the following housing. Housing provided under any state or federal program that the Secretary of HUD has determined to be specifically designed and operated to assist elderly persons. So there are state and federal program housing for seniors, okay? The next two are private housing. So let's say I'm a developer and I build a community for seniors. There's two types of senior communities on the private sector. So the first one was public sector, this is private sector. Intended for and solely occupied by persons 62 or older. That's one of the senior housings, solely by people 62 or older. That means the youngest person in that community, the youngest person in that community is 62, okay? The next one is the most common one that we know. It's the 55 plus, right? Intended and operated for occupancy of persons 55 or older. This is the most common exemption. Now, how do we qualify for the 55 or older? How do we qualify the community to be 55 or older? So a facility or community must satisfy, again, straight from HUD, must satisfy the following requirements. Have at least 80% of the units occupied by one person who's 55 or older. So what are we saying here? For the community to qualify for 50, to be a 55 plus, 80% of the community must be 55 plus. Okay, so hold on. Each household, 80% of the households have to have at least one person 55 plus. So where the previous one said the youngest person in the community is 62, this one says, hey, we don't care if one person is 55, the other one's 20. Okay. One of us in the household, one of us needs to be 55. You see the difference? One is strictly for 62 or older. This one is at least one of us needs to be 55 or older. Okay. Who's driving around? Seriously. These people. Huh? Drive around. All right. The facility, this is the other thing. The facility cannot just say, oh, we're 55 plus. No, they have to, they must publish and adhere to policies and procedures that demonstrate they intend to operate as a 55 plus. So not only do they announce they're 55 plus, they have to have publicly announced, so wherever everybody can see, right? That says, hey, these are the rules for the community. 55 plus, we don't accept children living here, or we do accept children living here for a certain period of time, or whatever the exclusions are. And these rules must comply with HUD's regulatory requirements for age verification of residents. So these three things must be in place in order to qualify for 55 plus. Now, the housing for older persons exemption does not protect such housing facilities or communities from liability for housing discrimination because of race, color, religion, sex, disability, or national origin. The only exemption they have is based on age. It's the only exemption they have is based on age. Guys, cameras on, please. And be stationary, very important. All right. Jones versus Mayer. Has anybody ever heard of Jones versus Mayer? It's a very important case. The second biggest event of 1968 when it comes to fair housing. The first one was the amendment. I knew somebody was going to say that. Emily, I heard of John Mayer. Yep. So this is Jones. So this case came after the 1968 exemptions. Okay, we'll talk about the exemptions in a second. So because exemptions were created, obviously to benefit some groups, right? Because exemptions are only created by politicians that have somebody, talking to them and say, hey, I know it's illegal, but can we do it this way and maybe get around it? That's why exemptions exist. Otherwise, it's pretty much black and white. I mean, don't discriminate, period, right? But no, how can we discriminate? So because of these exemptions, a developer refused to sell a home in St. Louis, Missouri, to Mr. Jones over here. So Alfred H. Mayer Company refused to sell a home to him. Now, in 1968, the Supreme Court rules, Jones versus Mayer, that all discrimination in selling or renting residential property based on race is prohibited under the provisions, okay, based on race, is prohibited under the provisions of the Civil Rights Act of 1866. So, while the Federal Fair Housing Act exempts certain kinds of discrimination, anyone who feels victimized by discrimination based on race may seek legal recourse under the 1866 law. So this case is the one that came to say, well, wait a minute. It's 1968. You remember 102 years ago, you guys came up with a law, the first law on discrimination. Are we about to forget that that law is the foundation for why we're here today? That's pretty much what happened. And then the judge says, you know what, Mr. Jones and attorney, you are right. Ignoring the first law, the foundation of this will be the same as ignoring the Constitution. So yes, from now on, it is ruled that any discrimination based on race is illegal. All the other exemptions, still valid. But if it's based on race, it does not matter if we read this before. If you're a real estate professional representing somebody, if you're the actual owner and saying, oh, I did not know, there's no excuse to discriminating based on race. Okay? You guys good? Give me a thumbs up if you're good. Okay. All right. Definitions. So HUD's regulations provide specific definitions that clarify the scope of fair housing, of the Fair Housing Act. Dwelling. A dwelling is any building or part of a building designed for occupancy as a residence by one or more families. So when you see the word dwelling, we're talking about a place that we can occupy to live, pretty much. This includes a single family house, a condominium, a co-op, and manufactured or other factory-built housing, as well as vacant land on which any of the structures will be built. Familial status. So Samaya had asked before, here it is in part of definitions. And the reason why it's here is because a lot of people get confused with this. This is family or familial status. Familial status is defined as one or more individuals under the age of 18 living with a parent or a guardian. It also includes a woman who is pregnant, so it could be just one person, as long as they're pregnant, and anyone who's in the process of assuming custody of a child under the age of 18. This is familial status. Okay. As we mentioned, housing that qualifies for older persons is exempt, but families with children must have access to single family and multifamily housing under the same terms and conditions as everyone else. It is unlawful to promote a property as being for adults only or as preferring a certain number of children. Landlords, condos, and co-ops are prohibited from imposing restrictions on the number of tenants with the intent of excluding families with children. And the occupancy requirements must be based on objective concerns such as cleanliness and security. So the only exemption besides HOPA, right? The only exemption to families with children, okay? So if you see an ad, and you've probably seen ads like this, hey, 3-bedroom, 2-bath, no kids, $2,000. If it says no kids, no children, whatever, that's illegal. Okay, you cannot say that. But Stephen, thank you. That's where I was gonna go to. The only exemption that we have is based on health and safety. So, sorry. So, if it's on health and safety laws, and we're going to get to the part in New Jersey where we address it as well. If it's based on health and safety laws, every state has a rule and every municipality has a rule regarding occupancy. So if the housing has only 2 bedrooms, like you were saying, right, and there's 7 kids, obviously we have a health and safety issue here. Can you discriminate based on that? Absolutely. Okay? You can, based on health and safety reasons. But if it's a 2-bedroom, husband and wife, 1 kid or 2 kids of the same sex, you cannot discriminate. Can you say of opposite sex? Can you discriminate? There's a possibility. Depending on local laws, you might be able to say, well, according to local laws, children above the age of 6, and these are some local laws, by the way, children above the age of 6, they are from the opposite sex, cannot be in the same room. So now you can claim law and say, hey, I'm not discriminating. It's health and safety hazards. All right. So, yeah. So you're not discriminating if it's 7 kids. No. Okay. All right. Disability. The term disability. The Fair Housing Act classifies disability as a handicap. However, the term disability is usually used. A disability is a physical or mental impairment that substantially limits one or more person's primary life activities and includes having a record of having such an impairment or being considered as having one, even if one does not exist. It is illegal to discriminate based on disability against prospective purchasers or tenants, and HIV-positive individuals are covered by the fair housing rules under this category. This classification does not include current illegal use or dependence on a controlled substance, which could be considered a disability when somebody's addicted, right? As defined by Controlled Substances Act. Although the law prohibits discrimination against persons participating in addiction rehab. So if somebody is in rehab, you cannot discriminate because they're in rehab. They're trying to come clean, right? For example, a landlord could illegally discriminate against a cocaine addict, but not against somebody in the drug recovery program. In the same way, as the Federal Fair Housing Act does not protect those who are current users of illicit or controlled substances, it also does not protect those who have been convicted of illegal manufacture or distribution of a controlled substance. So, if you're a criminal, known criminal, you can discriminate against that person, okay? If the person is in recovery of whatever their addiction is, you cannot discriminate. That's the gist of it, okay? Landlords are required to make reasonable adjustments to current policies, methods, and services to allow those with disabilities equal enjoyment of the property. It is acceptable to expect the landlord to allow a service animal, such as a guide dog, in a no pets building, or to give a designated parking space in an otherwise unreserved lot for a disabled person. Individuals with disabilities must be entitled to make reasonable and necessary adaptations to the property at their own expense. Now, hold on. We are going to talk about ADA again, like we did talk the other day. Do you guys remember what ADA is? ADA, you got to know this, this acronym, ADA. Stephen, I know you know, so you don't have to answer. Everybody else. Americans with Disability Act, exactly. So what we're saying here, we're talking about residential still. It's not commercial where ADA comes to play. And I did tell you when we talked about ADA before, I did tell you that there might be a question in the exam where if you're talking about residential, right? That's one of the questions in the school or state exam where it says, hey, somebody got into an accident, now in the wheelchair, and they asked the landlords to put a ramp, as an example. And then there's 4 answers. The landlord has to do it. The landlord has to do it, but collect from the tenant, right? And a few other options, right? You have to remember, individuals with disabilities, they must be entitled for reasonable necessary adaptations of the property, but at their own expense. To accommodate a person in a wheelchair, these alterations may include lowering a door handles, or installing bath bars. Failure to permit visible alterations is a criminal discrimination. But the legislation does acknowledge that some legitimate alterations may render a rental property unattractive to the general public. So to prevent that, the landlord may request that the property be returned to the original state at the conclusion of the lease, except for normal wear and tear. So what we're saying is very simple. Hey, we are going to install this, okay, at your own expense, but also at your expense, we need to remove this, okay? So as long as you're here, you can use the ramp. As long as you're here, you can use these adjustments, okay? That is a great question, Stephen, and the answer is yes. I don't have that here, but the answer is yes. You can ask for an additional deposit to cover the removal. That's it. To cover the removal, just in case. If it's removed and there's no issues, here's the money back. So licensees should be aware that state and municipal regulations may have more strict requirements. All right, exemptions. What is the Federal Fair Housing Act again? What is it about? Say it louder. Stop saying under your breath. You got it right. So discrimination. The Fair Housing Act is about discrimination in housing. You cannot discriminate. But what does this word mean then? What does it mean? Anybody? Loopholes, exactly. You can discriminate, yes. So what we're saying is we cannot discriminate, but if you really want to, here's how you can, right? You guys ready to find out how you can discriminate? Yes? Those there, raise your hands. I see you. I see how it is. They want to take notes. How can I discriminate? Teach me, please. How can I discriminate? I don't like these other people. All right. The Federal Fair Housing Act covers most housing, but does exempt. You got to remember this, almost guaranteed to be a question. Owner-occupied buildings with no more than 4 units. Owner-occupied buildings with no more than 4 units. So if you live in a 1 to 4 family, so no more than 4 units, this is federal law. State law is a little different. State law is stricter. So federal law, broad, state law, stricter, okay? If you live in a two-family, as an example, and you occupy one of the units, you can discriminate against who's going to live in the next unit. Okay? So I live here and I'm going to rent that unit right there, right? And I'm going to say, oh, Alexis, what's your background again? You don't know which one?
No, both.
Oh, you're a mix.
Yeah.
Okay. Even worse. I don't like you people, Dominican, Puerto Rican. Like, come on. Really? So you know what? You can now rent from me. As long as my advertisement, we're going to go over this too. As long as my advertisement is not discriminatory, once you get to the door, I can say, get out. The advertisement cannot be discriminatory, but because I live in one of the units and I'm renting the other unit, I can tell Alexis to beat it. Get out of here. Okay? And I was joking about the whole Puerto Rican Barican. Okay. You're Arab too?
My father, in our hospital.
What a mess. I thought I was bad. Wow. Zoraida goes like, no more fungo for you. I love it though. I used to go to North Newark just for that. I used to live in North Newark, right next to a Dominican restaurant. Sia says, as a licensed professional, no, okay, so we're talking about the owner occupied right now. This we're talking about the owner. Okay. We are going to get to us in a little bit. Alexander goes, not different from the Portuguese. Let's go to the Brazilian then. Guys, there's no pure breed anymore. Come on. We've been on this earth for billions of years. There's no pure breed. Stop the whole racism thing. We're mutts, all of us, whether you want to admit it or not. We're all mutts. I got Indian, I got French, I got African, like in my family. It's so ridiculous. You guys cannot see because of my color, but I'm very Indian. If you see my mom's family, oh, at my mom's funeral, there's these people walking in, and I'm like, I think they got the wrong place. And now I'm joking, obviously. At the time of the funeral, I was not, but I see these people there, and some of my family comes to me and says, Bruno, I'm sorry, I know you're not in the right state of mind, but there's these Indian people over there. And I'm like, what? And I started looking around, and there are these tiny Indian people from India, right? These tiny Indian people. And I'm like, I look, oh, that's my aunt, that's my uncle, and that's my cousin. Everybody on my dad's side of the family, they're looking at me like, what? You're Indian? You never noticed? Yeah, I'm Indian. So we're all mixed. Lewis says, I'm pure American. I'm sure. All right. So Stephen, yes, I'm going to get to that. If you are involved in the transaction, I'll get to that as well. All right. So right, it said, make me laugh. Anyway. All right. So that was one of them. The next one is single family housing sold or rented without the use, right here. Without the use of real estate professional. So if we are involved, these don't apply anymore. Okay, if we are involved, these don't apply anymore. But if it's a for sale by owner under federal law, and guys, remember I told you state was stricter? Right now, we're just learning about federal law. If it was advertised for sale by owner, single family, they can sell or rent and discriminate, okay, under federal law, as long as they're not using a real estate professional. Housing operated by organizations and private clubs that limit occupancy to members. We'll talk about that later, a little bit better later. The rental of rooms or units in an owner occupied. This might be a question in the exam as well. The rental of rooms or units in an owner occupied building of no more than 4 units is also exempt in the Fair Housing Act. So there might or might not be a question in the school or state exam that says that, Jane wants to rent a room in her apartment, but she advertised as female only. Which law does this violate? The answer is none. Because I live there and I'm renting the room to a same sex or same gender. All right. So it does not violate any laws as long as it's owner occupied. Okay. The sale or rental of a single family home is exempt from the Fair Housing Act, as we know already, if it meets these conditions. The home is owned by an individual who does not own more than 3 such homes at one time. A real estate professional is not involved in the transaction. We already covered that. And the third thing that I was mentioning, discriminatory advertising is not used. Your advertising cannot explicitly discriminate. Again, when you get to the door, I can tell you get out, but my ads cannot say that. We were talking about private clubs, right? So let's talk about private clubs real quick. Housing owned by a religious organization, private club, right, may be restricted to members of the same religion if the membership is not based on race, color, or national origin. A private club that is not open to the general public may restrict the rental or occupancy of accommodations to its own members, as long as the lodgings are not managed for commercial purposes and must be open to individuals of all races, colors, and nationalities. Now, the reason why I address these two under the club section is because you are members of it. All right. So I don't want anybody upset when I said religious organization, private club. But that's the reality, right? Don't get offended. But if you're a member of 24-hour fitness, can you go work out at Retro Fitness? If you're a member there, or if you're a guest, maybe. But you're not. If you're not a member or you're not a guest, you cannot go. If you're from a Christian church, can you go to another Christian church? Sometimes they don't allow you. Who are you? Right? If you're a Christian and go to a Catholic, if you're a Muslim and you go to a Christian, whatever it is, we can stop you from going there if you're from a different denomination, or if you're not a member of this particular church. Masha said for $20 a day, you can go to a Christian church. Oh, the gym? Okay. I know, I'm just messing. My migraine does not allow me to read properly, but I still got that one. But yeah. But I'm pretty sure you can go to any church as long as you contribute as well. It's like immigration. You'll never get kicked out of this country if you don't commit a crime and if you pay taxes. You don't have to be legal. I'm not telling you not to change your status, but you don't have to be legal. As long as you pay your taxes, nobody's coming after you. You're a law-abiding citizen. If you commit crimes, then that's a different story. All these entities care about, and again, don't get me wrong, I'm not talking about an individual preaching, right? I'm talking about the global organizations. All they care about is money. As long as you're contributing, nobody cares what you do. The moment you stop contributing, so the IRS only comes after you if they feel like you're evading taxes. That's it. If you do things right, you don't have to pay taxes. They just cannot feel that you're evading taxes. You just got to know how to work the code. That's all. Anyway. Steven says you can do both. Go to the gym for $20 and go to the church for $20 a day. All right. So it has to do with membership. That's what it is. Now, Fair Housing Act does not require housing to be made available to a person whose tenancy would pose a direct threat to the health and safety of others or would cause considerable physical damage to the property of others. So we already covered this when we talk about you're too funny. Make sure you do a big crime and pay taxes. What did I tell you? The CEO of Countrywide walked out of that courtroom with a $94 million lawsuit, right? Judgment against him, and he was still happy. right? The stump or whatever it is from Wells Fargo, $20 million, and he got a severance pay. As long as he's paying his taxes, he doesn't go to jail. You stole 20 million, but you paid this much in taxes, you're good. Right? Madoff is a different story in case somebody's going to write about Madoff. It's a different story. He was paid to go down before the whole system went down. Madoff is kind of like the scapegoat, like, hey, you got to go to jail. We'll take care of you and your family outside. Anyway, these conspiracy theorists, huh? All right, Americans with Disability Act. We already talked about this in the previous chapter. Let's go over this real quick. Despite not being a housing statute, the Americans with Disability Act has substantial impact on real estate business. The ADA mandates reasonable accommodations in employment and access to goods, services, and public buildings. The law is significant since real estate professionals are frequently employers whose offices are public locations. The purpose of the ADA is to integrate those with disabilities into the economic and social mainstream of society. And I think you guys noticed more and more people with disabilities working at regular jobs, right? Now, ADA exempts from its requirements property that is covered by Fair Housing Act, which already prohibits discrimination based on disability. Property is exempt from coverage by the Fair Housing Act, such as housing for those age 55 or older. Some properties are subject to both laws. For example, in an apartment complex, the rental office is a place of public accommodation. As such, it is covered by the ADA and must be accessible to persons with a disability at the owner's expense. Individual rental units will be covered by the Fair Housing Act, and a tenant who wish to modify the unit to make it accessible would be responsible for the cost. We also kind of covered that already. Okay. This one is one that it's not usually tested in the real estate exam. It's tested obviously in the mortgage exam, but it's something to know, and I'm pretty sure it's going to be brought up in one of the future exams. It's called Home Mortgage Disclosure Act, the HMDA. When you take the mortgage class, you're heavily tested on this, on the things you can and cannot do. So it's good to be aware that your lender cannot do certain things. This statute requires lenders involved with federally guaranteed or insured loans to exercise impartiality and non-discrimination in the geographical distribution of their loan portfolio. In other words, the act is designed to prohibit redlining. It is enforced in part by requiring lenders to report to authorities where they have placed their loans. All right, forms of illegal discrimination. Real estate professionals must follow fair housing and other civil rights laws on a regular basis if they are to achieve their goal of prohibiting discrimination. Compliance also implies that real estate professionals avoid violating not only the law, but also the profession's ethical standards. Discriminatory misrepresentation. An agent may not conceal available properties, represent that they are not for sale or rent, or alter the sales terms to discriminate. A lot of pocket listings is a little different. Let's put it's different depending on the intent. Okay. So there's a few realtors out there and homeowners that this is what they do. I saw last year, I was talking to somebody, a realtor that says, oh, I got this client in Hillside, has his property for rent. If you know anybody, it's a 3-bed. I don't remember how many bedrooms there was, but 3-bedroom, 2-bath, right? If you know anybody, we're getting a bunch of calls, but it's not the people that the landlord wants. And I'm like, wait a minute, what do you mean? They don't qualify financially? Oh, no, they actually make a lot of money. These people are calling. Okay, their credit is bad? No. The landlord doesn't want Indian people, and those are the people that are calling. I'm like, a broker, by the way. Mr. Broker, you do know that that's illegal, right? You do remember that from your salesperson class, from your broker class, and from all the CE credits you've been doing for all these 10 or 12 years, right? You do remember that it's illegal. It's like, yeah, I know, but he doesn't want it. I'm like, so walk away. Your job, and we're going to talk about this, your job as realtors, if the seller or the landlord intends to discriminate, your job is to walk away. There's plenty of fish in the sea. Thank you. Next. I'm not working with you, Mr. Discriminator or Miss Discriminator. Next. There's plenty of people out there to work with. Okay. The more we allow this to happen, the worse it gets. We need to stop this. Okay, we need to stop the discrimination. Okay, do you guys know what's the best color in the world? The best color in the world. Green. That's it. Why? No, not the rainbow. Green. What color is love? What do you? I said the best color. The writer goes like love. There's a color to that. Green. Why is it green? Because if you do your job right, what happens? You get the green. You get paid. All right. That's the only color out there. The best religion in the world, now that you are professionals in the real estate business, the best religion in the world is real estate religion. And your Bible, your Torah, your Quran is now the real estate laws. When you're practicing outside, when you're not practicing, freedom of doing whatever you want. While you're practicing, that's your religious book right there. That's your religion. That's what you follow. Does that make sense? Okay. No discrimination whatsoever, guys. Please avoid it. Okay. You cannot say, oh, for you, this is not available. Right? Discriminatory advertising. A real estate agent may not advertise residential properties in a way that limits their availability to any prospective buyer or tenant. We'll give you some examples later. You can now offer unequal services. That makes sense, right? I'm going to move right forward. All right, blockbusting. This is something to remember. Blockbusting or panic selling. You got to remember this one. And the next one and the one after. So, what is blockbusting? You guys remember Blockbuster? I always give this example. I've been doing this for years. You remember Blockbuster? What was Blockbuster?
But I know,
What are you thinking about?
I was thinking of books. Never mind.
Ghostbusters?
No, I was thinking of something else.
Did
but
you
I
say
know
Ghost?
about-
Oh, okay. It was a movie rental place. Yes.
That's right.
Blockbusters. All right. Now, what made Blockbuster different from any other rental place? What was the difference? What was the difference between them and everybody else? Why was it called Blockbuster? Who knows? Late fees. That would be Wallet Buster. The thing about Blockbuster, guys, is that they had the latest and greatest. As soon as it got out of the movie theaters, it would be at Blockbuster. And if you wanted to watch, because you didn't watch in movie theaters or because you really want to watch it again, if you wanted to watch, you had to be quick because the day it was released, right? If you didn't get there on time, it was empty shelves, right? The shelves were completely empty. Same as a Black Friday, same as those rush promotions. Okay, they created what's called FOMO, which is the fear of missing out. That's what blockbusting is. Scaring people, creating panic, right? And say, hey, do this or else this is going to happen, right? So blockbusting or scaring property owners is inducing property owners in the neighborhood to sell or rent to avoid an impeding change in ethnic or social makeup of the neighborhood, which will cause the property values to fall. According to HUD, the profit motive is critical component in blockbusting. A property owner may be intimidated or scared into selling a property at a low price to the blockbuster, who then sells the property at a higher price to another person. To avoid being accused of blockbusting, real estate agents should exercise caution when selecting locations and methods for marketing their services and soliciting listings. For example, Agent Smith tells, not the guy from the Matrix, okay? Agent Smith tells neighborhood owners that several minority families are moving in and that they'll be bringing their relatives next year. So Smith informs homeowners that in anticipation of a value decline, several families have already made plans to move. By doing this, I'm telling you, Mr. or Mrs. Homeowner, let's sell now before, right? But why are we doing this? It's not because of a market change. It's because, hey, these group of people are coming in. That's discrimination. Okay? You're creating panic selling or selling, inducing a homeowner to sell the property because of the potential change in the neighborhood. Okay? Steven says, can I do the opposite? What do you mean? Fancy pants are moving in, prices are going up. So, the issue about blockbusting is creating the panic and cutting a potential gain for the seller. So I'm trying to see where that would be. What's your point with this one? Because if prices are going up, then I'm going to stay. I'm going to wait for the prices to go up. You're just telling about anticipation of developments. Oh, okay. So is it blockbusting? There's a lot of things you guys trainings that you guys going to learn that I cannot cover here in depth about blockbusting and steering being the next big thing. And it ever evolves. So you have to look at HUD guidelines to see how it changes over the years. There's stuff that today is allowed or it's prohibited that back then it wasn't, in terms of advertisement, in terms of enticement, in terms of motivations, right? So it becomes very difficult. I don't think you should do that, but let's put it like that. Law says if it's based on people, don't do this type of advertisement. If it's based on market economics, then you can say, hey, prices are going up. So that's pretty much what we're trying to cover here in terms of blockbusting, steering, and the next one, redlining, is like keep it to myself and buy. That's different. So okay, so then there's the other thing. What do I know about the market as an investor versus what do I know about the market as a realtor? You see what I'm saying? Am I scaring? Because here's one of the issues. The realtor was buying here. Okay. They're buying at a low price. So that's one of the issues. Are you taking advantage of the situation? If you are a licensed professional, right? This is what we're talking about. If you're a licensed professional, you got to be very careful. It's one of the reasons why I didn't get my real estate license until like 10 years in the business as an investor. It was almost 10 years when I finally decided to get my real estate license. Okay? Because I was scared about this whole, like, what can I say or not say that will not get me in trouble, right? So taking advantage of the market drop, right, would be the same. If you're taking advantage of market drops without damaging the other party somehow, right, as a professional, meaning they didn't call you for an assessment. The conflict of interest would be, hey, Stephen, I need to sell my property. And you go there and say, you know that market is declining or increasing or whatever, and you don't disclose that. That would be a conflict of interest. If you as a professional took advantage of that, then you're in trouble. If you as an investor, not licensed, took advantage of that, then it's bargaining, it's negotiation. You know what I'm saying? You see what I'm trying to say? So that's where you need a raffle. So I'll tell you what, some people ask me, hey, what about if my wife is not licensed and I tell her? What about if, it's not inside trading because it's not me, she did it on her own, right? So if it somehow can be associated to you, yes, it is a problem. Anyway, guys, let's move forward. Blockbusting, scaring people into selling because of minorities. This is where we're talking about discrimination based on minority groups or change in the racial composition of the neighborhood. The next one was steering. Hey, steering. Who has a car? Just as it sounds, who has a car? If you got a car, when you sit in the driver's seat, or if you don't have a car, when you sit in the passenger seat, you see something there on the driver side. It's called a steering wheel. What is a steering wheel used for? Just to take you either to or away from a particular area, right? Either to the left, to the right. If you accelerate, you go forward, right? If you put it in reverse, you go backward. But the steering wheel is what takes you out of that particular place that you're at, right? Steering, when it comes to discrimination, steering is us taking or directing customers or clients towards or away from homes and neighborhoods, either directly or indirectly. Steering occurs when an agent describes an area in a subjective manner to encourage or discourage a buyer about the suitability of the area. For example, an agent may inform buyer A that the neighborhood is extremely appealing and that desirable families are moving in on a weekly basis. The following day, the agent informs buyer B that the same neighborhood is deteriorating and the values are beginning to fall. The agent has clearly directed buyer B away from the area while directing buyer A into it. Happens a lot of times, right? You look at somebody and have a perception of where that person should be, where they belong. Sometimes we don't do it like with malice. We don't do it like, oh, you're Puerto Rican / Dominican, right? So I'm going to put you in North Newark. That's where you belong, right? And then I'm going to look at somebody else and be like, oh, you want to buy North Newark? You don't belong there, right? Sometimes you do it not intentionally, right? Sometimes we just assume based on our perception, right? This is why we always got to ask what the customer's preferences are. All right. It's not up to us to say you don't belong there. All right. It's up to them to research the market. All right. If they ask you, hey, what's the predominant racial composition in that particular neighborhood? Unfortunately, I cannot provide you that kind of information. We can pull reports, and whatever the report says, here, I cannot provide you that. You can research, and I can pull a report like Zillow talks about that. You can go on Wikipedia and put the zip code that tells you what the majority is, right? You can do that. Unfortunately, I personally cannot indicate that type of racial composition because now, for instance, the Ironbound section of Newark, until recently, was predominantly Portuguese. Before the Portuguese, it was Italian and Polish. Before them, I don't know, but we kicked the Italians and the Polish out, right? And then the Brazilians came and started kicking us out. And then this Hispanic groups came and started kicking the Brazilians out as well. It keeps on moving. It's a shift, right? But me saying that the Ironbound is Portuguese, right? Me saying that predominantly Portuguese would be false, right? And discriminatory to the other races there are in that particular area. Does that make sense, guys? So we have to be very, very careful when we make these assumptions. Rodizio. Well, since you brought that up, if somebody says, oh, I would like to live in the Brazilian area. Since you brought up Rodizio, Stephen, here's what you can do. Look, I don't know, I cannot give you that type of advice. I can show you a couple of Brazilian restaurants or supermarkets if you like. You could be close to them. That's different. I'm not saying that it's Brazilian area. I'm saying there's a Brazilian restaurant or there's a Brazilian supermarket. Does that make sense? Where would you like to be as well? Near transportation? Great. I know a great Brazilian restaurant that's near transportation and a supermarket that's not that far. You see what I'm saying? These are facts, not discriminatory. There's other stuff there as well. Okay. So you can't provide the demographics. Like I said, you can pull a report, a market report, and that report will say it for yourself, for itself. You cannot claim that that area is particularly Portuguese or the majority Portuguese or the majority Brazilian or the majority Mexican or the majority Ecuadorian or whatever. You cannot do that. That is illegal to do. Again, because it is discrimination against other communities. You can pull a report and let them decide based on that report, or you can ask them to do the research on their own of what areas they would like to live within the Ironbound or the Forest Hill section or South Newark section, whatever Vailsburg section as an example. So they will have to tell you exactly where they want to be. You pull a report based on that particular area and the type of property they're looking for. Next one is redlining. Okay. Redlining has to do with a red line. Okay. Not the UB40 song, for those of you guys that remember UB40 with red wine. Red line. This is where we literally go on a map and we draw a red line and say, hey, I'm not providing any type of financing on properties that are in this particular area. So I would have a map. I would put some type of boundary on that map and say, hey, no loans in this area. Redlining, that's literally what it is. So a lender cannot refuse. When you see redlining, you look for the answer that talks about refusing or rejecting loans in a particular area. Okay, redlining is refusing or rejecting loans in a particular area. Okay. All right, appraising, we had a whole chapter on appraising yesterday. All I got to say is that when an appraiser appraises, he or she also cannot commit any type of discrimination, okay? Restricting MLS participation. MLSs cannot restrict the type of people that will be listing there, or properties that will be listing there, and we cannot reject that either. Intent and effect. The intention to discriminate is clear if a licensee or owner deliberately engages in blockbusting, steering, or other unfair practices. Owners and real estate professionals must examine their activities and policies carefully to determine whether they have unintentional discriminatory effects. And whenever policies or practices result in unequal treatment of people in the protected classes, they are considered discriminatory, regardless of any innocent intent. So like I said, sometimes we don't do it on purpose, but the fact that we did it, right, is what matters. Nobody's going to say, oh, okay, you didn't intend, so I accept the discrimination. No, avoid it at all costs. Regulatory organizations use this effects test to assess whether a person has experienced discrimination. All right, response to terrorism concerns. I'll give you a break in a second. Response to terrorism concerns. In response to terrorist attacks, landlords and property managers have been developing new security procedures. These procedures have been designed to protect buildings and residents Landlords and property managers are also educating residents on how and where to report signs of possible terrorist activity. At the same time, landlords and property managers must ensure that their procedures and education do not violate others' fair housing rights. Why am I addressing this? Because there might be a question very similar to what we're going to go over right now. It is illegal to screen housing applicants based on race, color, religion, gender, national origin, disability, or familial status during screening and rental procedures. The Fair Housing Act does not expressly prohibit discrimination based on citizenship status. And as a result, asking applicants for proof of citizenship or immigration status during the screening process does not violate Fair Housing Act. There might be a question in the school or state exam that talks about citizenship status. Can I ask for it? Yes, I can. Okay, here's an example. During an interview with a landlord, a woman mentions leaving her home country to attend. Stephen, this is still under federal law. States can be stricter than federal law. This is federal. We will get to the Jersey as well. During an interview with a landlord, a woman mentions leaving her home country to attend a local university. The landlord is concerned about a woman's visa, which may expire during the lease term. And this makes sense because if you can't renew your visa, you might leave. So I need to know, just like a lender does this as well. Again, federal law, a lender can check your citizenship status to see if they can lend to you or not. Because somebody with a temporary visa can buy property here. Because they can, if it's a student visa, they can renew that visa. If it's a work visa, they can renew that visa. But they're always going to be with a higher interest rate or some more restrictions of down payments because of the possibility of expiring during that term. Okay. The landlord requests documentation from the woman to determine how long she can legally reside in the United States. And as long as the landlord requests this information, regardless of her race or national origin, the Fair Housing Act has not been violated. Now, if I'm asking for your citizenship status because you are Hispanic, because you are Portuguese, because you are, or some type of European, some type of African, some type of Asian, because if that's what I'm doing, right, then that's discrimination. If my concern is solely because of, wait a minute, will you be able to afford this? Or will you be able to complete it if your status expires? Does that make sense? So that's where there's a very thin line. In some states do have that restriction and say, hey, might as well not do it. Okay, so federal law, just like before, I mentioned that owner-occupied 1 to 4 family, it's okay to discriminate, right? Federal law says you can do this. State laws might be stricter when it comes to it. Okay. Finally, right before the break, okay, Zoraida. Right before the break, equal opportunity housing poster. In 1972, HUD instituted a requirement that brokers display standard HUD poster, and the poster affirms the broker's compliance with fair housing laws in selling, renting, advertising, and financing residential properties. Failure to display the poster may be construed as discrimination. When HUD investigates a broker for discriminatory practices, it may consider the broker's failure to prominently display the equal housing opportunity poster as evidence of discrimination. So yes, just because the poster is not there could be enough reason for them to start labeling you and your agency as discriminatory. If a real estate brokerage is accused of violation of fair housing and has not displayed the poster, the burden of proof may shift from the complainant, which is the party alleging discrimination, to the broker. This means that the broker would have to prove that no discrimination occurred rather than the complainant proving that discrimination occurred. So as I said before, because you're the licensed one, because you are the professional one, the burden of proof is always on you. Once they start checking off, okay, step number one, step number two, okay, no poster. Okay, no poster. So yes, they discriminate. Check number two, oh, they fail here too, right? So as they go through the list, they're building a case against you because you are the professional. You are always the one at a loss. You always have the burden of proof here. All right. This is the poster. There's a federal poster. When we get to the New Jersey portion, there's also the Jersey poster. If you guys ever come here to my office or to the school, as you walk in, both posters are there, both the federal and the state. If you don't see it when you walk in, you see it when you walk out. If you don't see it either way, it's because you're blind. It's right there by the door. As you open the door to your right, boom, right there. It is illegal to discriminate. That's what it says. You have a house over here with an equal sign. It's illegal to discriminate. Every single broker must have this posted in the place of business. What is a place of business? Not just the agency. If I have a model home for an apartment complex or leasing office or anything like that, guess what? Has to be there as well. Okay, not just the agency. And pretty much sums what we talked about. Cannot discriminate based on race, color, religion, sex, handicap, family status, national origin in the sale, in the advertisement, in the financing, in the provision of broker services, in the appraisal, and blockbusting is also illegal. So it covers pretty much everything we went over. All right. So we only have, you guys give me 10 more minutes because then we take a break and go to the next chapter. We only have 2 pages to go. Okay, and this is fast, I promise. Just a few key things to point out. We'll take a break. The next chapter is shorter than this one. Enforcement. Remember, Stephen, we're talking about it's difficult to prove. Look what the law says. This is also directly from the law. People who feel that they have been discriminated against under federal fair housing laws may file a complaint with the Office of Fair Housing and Equal Opportunity within HUD, or they may file a lawsuit in federal court. Keywords: feel. I feel discriminated against. I'm suing you. Okay. Now you can file a complaint, like I said, file a complaint with HUD, right? Under the Office of the Fair Housing and Equal Opportunity. And complaints alleging fair housing violations must be filed with the Office of Fair Housing and Equal Opportunity within 1 year of the violation. Okay. If it's a complaint, this is what you got to remember. If it's a complaint under federal law, complaint, 1 year. HUD then initiates an investigation in conjunction with federal and local enforcement authorities. And if HUD decides that the complaint merits further action, it will attempt to resolve the matter out of court. If efforts to resolve the problem fail, the aggrieved party may file a lawsuit in state or federal court. This was a complaint. If you're filing a lawsuit, in addition to the complaint or instead of the complaint, a party may file a lawsuit in federal court or state court, and they have 2 years of the alleged violation. So if it's a complaint, you have 1 year. If it's a lawsuit, you got 2 years to do it. Otherwise, it expires. You cannot complain anymore. Okay? Here are the penalties. The offended party may seek remedies via administrative actions. The proceeding before an administrative law judge, from here on, I'm going to call him ALJ, okay? Administrative law judge, is an administrative proceeding. The administrative law judge can award actual damages to a harmed party and impose a monetary penalty if it is considered that the public interest would be served. Effective August 16, 2016, HUD increased the maximum civil penalty for violations to the Fair Housing Act. And after adjusting for inflation, the fines are, for first violation, 19,987. For second violation, I don't know why I didn't round up these numbers. I don't know. For second violation, if it happened within 5 years, obviously of the previous one, it's 49,467. For a third and subsequent violations, within 7 years, it's 98,935. The state exam is not going to ask you about these fines specifically, right? But you can tell how much money you need to make to cover your discrimination if you intend to discriminate. So you need to sell 2 houses for your first one, unless they're $1 million houses. You need to sell 4 houses for your second violation, if you intend to. If that's what you guys want, you want to discriminate, just make sure your first 4 houses cover the complaints. All right. Here's the problem. I'm not worried about those penalties. I'm worried about this. In addition to the civil penalties, the victim of housing discrimination may be awarded actual damages, so whatever they suffered, attorney fees and costs, right? The administrative law judge may also issue an injunction. Injunction means an order for you to do something. So, ordering you to rent the apartment to the complainant or stop from doing something, like stop engaging in discriminatory manner. But there's more. It's not just the fines, it's not just the penalties and the injunction or the order to do something. The Attorney General can also initiate a civil action against you in the federal district court if there's good grounds to think that that person or group is engaging in a pattern or practice. So if it's not like the first time, if it's a pattern, hey, let's bring a heavier lawsuit, right? Now, in addition to the victim's actual damages, the Attorney General, the attorney fees and costs, as well as compensation for humiliation, mental distress, and loss of housing rights, civil fines may result in a maximum of $50,000 for first offense, $100,000 for second offense, and subsequent offenses, on top of the previous one. We're not done yet. There's more. Under the Civil Rights Act of 1866, complaints are brought directly to federal courts. So if it's based on race, you got to go straight to federal. And for matters heard in federal courts, punitive damages can be unlimited. That means whatever the judge feels like. The only time limit for this action is the state statute for limitation for torts, which are injuries that one person causes to another. Okay. So you guys saw how heavy the fines can be, how heavy the damages can be. Who intends to discriminate? Who wants to discriminate? Raise your hand. It's only a couple $1 million at the end of the day. Come on. No? No? Okay. What if your client discriminates? This is the last thing. What if your client discriminates? Fair housing laws apply to home sellers as well as to agents, except for the exemptions previously cited. If an agent goes along with a client's discriminatory act, the agent is equally liable for the violation. The agent is equally liable for the violation of fair housing laws. So if they get sued for all those millions, guess who's getting sued for all those millions? You are, okay? No biggie, right? Just a couple of millions, that's it. So it is crucial to avoid complicity with client's discrimination. Further, an agent must withdraw, walk away, thank you, Jefferson, from a relationship where the client's discrimination occurs. So if they intend to discriminate, please walk away. Here are some examples of client discrimination. Okay, and this is it. This is the last page, guys, for the break. Refusing to a full price offer from a particular party. If you get a full price offer, why would you refuse? Because you're waiting for better offers, maybe. But if that particular party is maybe the only offer, or maybe the best offer, but that particular party is different from you. Like it's a little darker, a little lighter, different religion, different, whatever it might be perceived at, you have to question. Like Mr. or Mrs. Seller, full price offer. Why wouldn't you accept this one? You have to inquire about it. If it has nothing to do with race, you can move on. But if you feel like it has to do with race, you have to explain to them. In fact, when we get to the New Jersey portion, New Jersey requires you to provide a memorandum at the time of listing, a memorandum by the Attorney General that says, hey, it's illegal to discriminate. Okay. Removing the property from the market to sidestep potential purchase by a party. Accepting an offer from one party that's lower than from another party, as I said before, right? What about threats or violent behavior? What can we do when there's threats or violent behavior? Working in real estate is not generally considered dangerous, but some real estate professionals may face threats or violence simply for following fair housing laws. The Fair Housing Act protects the rights of people who want to take advantage of fair housing laws. It also protects property owners and real estate professionals who assist or encourage the exercise of fair housing rights. Threats, coercion, and intimidation are all criminal offenses. In such a case, the victim should immediately report the incident to law enforcement officials. So immediately you call the cops or even the FBI. I didn't put that here, but if it's threats of violence, you can put a complaint with the FBI. Okay, that will already start putting a record that this person is dangerous. Not that they'll do anything, they'll wait until the mass murder, but at least the complaint is there. Too dark before the break? Yeah. It's the truth. If you guys look at all these shootings, FBI has a long list of warnings about these people every single time. Yet they choose not to do anything. It's just a warning. Let's wait and see what happens. What are the repercussions for professionals in real estate? Creating and sustaining an open housing market is largely the responsibility of the real estate industry. Licensees are the real estate experts in the community, but with the privilege of earning from real estate transaction comes the social and legal obligations to preserve the civil rights of all parties. Developing partnerships with community and fair housing organizations to discuss shared concerns and identify solutions to problems is very beneficial, as real estate professionals who actively work to enhance their neighborhood will gain a reputation as caring residents, which could result in larger clientele. Fair housing is mandated by law. As such, anyone who breaks the law faces severe consequences. In addition to financial penalties, a real estate professional's income may be at risk if their license is suspended or revoked, right? They suspend your license, all the transactions that you have pending, they don't go to you. It's not a defense that the offense was unintentional. We already said that. Oh, I didn't do it on purpose. Nope, doesn't work like that. Real estate agents must analyze their operations and take special precautions to avoid falling prey to clients or consumers who anticipate discrimination.